Does outrage lead to unconstitutionality? Let's see how it turns out to be. The outrage we feel when an upper caste person pees on a tribal which is almost inexpressible. In response, the state also acts unconstitutionally, leaving one equally unconvinced. The latest example takes its origin from the state of Madhya Pradesh, where the government simply had to apply the SC and ST Prevention of Atrocities Act and pursue prosecution vigorously. Due to the rarity of convictions under this act and the often poor quality of investigations, that extra effort would have been necessary. As a result of the Supreme Court's dilution in 2018, the amendments to overturn the dilution have been upheld, of course, in 2020. As is the case with Madhya Pradesh, Dalits and tribals continue to suffer from indignity, harassment, and intimidation aimed at stifling their voice. Although the offense was appalling, we shouldn't ignore the law. In the state of Madhya Pradesh, it first booked the suspect under the National Security Act, an unusual misapplication, and then, as has become a regular occurrence in UP and MP, demolished the home of the accused. As a result of an official action that is unfounded in law, a family now finds itself homeless. Bulldozing houses in UP and now in MP, particularly before the elections, is like copying the strategy of UP in MP. But for those holding constitutional offices, the law does not seem to apply. However, bulldozing is not a foolproof political strategy. Of course, one should consider the tribal vote. At the same time, one should also consider the demolition's effect on upper caste anger. Further, if this anger leads to more atrocities against local tribes, then the tribal vote is also not a sure thing. When police protection is removed from tribal members, they always fear repercussions, regardless of where they are located. However, politicians needs to stop bulldozing, and in the case of Madhya Pradesh, the Supreme Court must step in and declare it unconstitutional. It is said that those in power abuse the law. In the first place, an upper caste criminal who peed on a tribal should be dealt with as a criminal with no mercy shown. But at the same time, the state should not take the law into its hands and bulldoze his house before law tends to act on the said criminal for his criminal act of peeing. If we see the larger picture, both the acts, the act on the part of upper caste individual peeing on a tribal and the act by the state in bulldozing his house, are both unconstitutional acts. Even washing the victim's feet may not be of any help excepting for eye-catching photo opportunities, because the victim, as a part of atrocities act and crimes, should be investigated professionally and conviction should be obtained in a court of law. And the use of bulldozers to punish a perpetrator's family is extremely troubling. Of course, this kind of practices are prevalent in Israel, which is a country where this kind of bulldozing happens. As we discuss the relationship between the rule of law and a democracy, a fundamental distinction should be drawn between rule by law and democracy, whereby law is an instrument of government and government is considered above the law and rule of law, which implies that everyone in society is bound by the law, including the government. Democracy requires adherence to the rule of law as a fundamental feature of constitutional limits on power. Lastly, we need to remember the verdict of the Guwahati High Court, which held that bulldozing of a house is not covered by any criminal law, even when a serious matter is under investigation by a government agency. Hope the information is useful to you all. Thank you very much for your patient hearing.